All right. Yep. It's another day. It's just another day. Da, 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 da. It's just another day. Hmm. Can't hear anything.
Page
Here.
72.
The national flag is within discretion of president acting as commander in chief of the Army and Navy. Is this a common law court or an admiralty court?
The records reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is wearing a dress shirt. I know he has a suit coat, but it's not on. He's also wearing a mask. The court is not going to address any of the issues that he was in the other of those to the state as well. They are also uploaded. Instructions or lack of consent.
I don't consent to being called that name or identity that is recognize that name, nor do and we still have yet to address subject.
Oh boy, subject matter jurisdiction. You just knew it was gonna be another day of this stuff.
May I receive those original copies time stamped?
Okay. All right, I need to make a record of one part of a jury instruction that I do need to advise the jury. It will also be corrected in the packet. I believe within the last year, the jury instruction on credibility of witnesses was modified by the jury instruction committee, and it was just an oversight on the court's part to not include, it's really just one paragraph. It was read to the jury at the beginning of the case with the preliminary instructions, but it is a paragraph regarding implicit bias, and so I do think it's important to advise the jury of that. I intend to do that when they come out, and then again, the full instruction will be amended so that it's in the packet that goes
I have a feeling it's gonna
to
be
the
a while
jury.
before they get to come out.
And Madam Clerk, if you haven't already, if you can print off page 72. It's the, it adds a paragraph before the last paragraph that starts with, "There is no magic way for you to evaluate the testimony." And again, I wanted to be consistent with the most recent version of the jury instructions and consistent. And so I also, Madam Clerk, if you could just make the change as sure it's
Copies of my filings from earlier, time stamped.
Mr. Brooks, I'll provide you with the copies later on. I need to continue with the instructing of the jury and have the parties make their closing arguments.
Your Honor, with all
I did-
respect, the state received copies. How come I can't receive the copies of my filings?
You know what, I can give you the print-offs, but I can't give you the originals right now. That's what I'm referring to, and you will absolutely get those back. I guess I was mistaken that you wrote copy on it. I thought you retained a copy for your records. So with that, Madam Clerk will print off from the record. It won't be the yellow copies just yet. I'll take that up later outside the presence of the jury after the case has been given to them. Now, in terms of the closing arguments, I did set a time limit for the parties yesterday. Each side will have a total of
1
hour. Mr. Brooks, so that you are fully aware, the party with the burden of proof, which is the state of Wisconsin, goes first. Then you, as the opposing party, will have an opportunity to respond and argue. And then time
He's gonna argue.
willing, the state also has the opportunity to present rebuttal because they have the burden of proof. And that is provided with the excerpt from the bench book that was provided to you yesterday. It has the purpose of the closing arguments is to summarize the facts, marshal arguments, focus the issues for the jury. I just talked about the order of the arguments. The scope of the arguments are the content, duration, and form of argument are within the court's discretion. That's why I set a time limit of 1 hour for the parties. And Mr. Brooks, I will advise you that I certainly will wait and see how you present your argument today. I will certainly wait to see if there are any objections raised, but I also want you to be aware that if I feel the arguments are improper, I may simply, without an objection, say, please move on, as a clear indication from this court that what you are stating is not proper under the
Here it comes.
various rules and case law that govern closing arguments.
He's gonna throw a
Again,
fit.
Your Honor, without prejudice, I'm here by special appearance. I don't consent to being called that name for the record.
It's noted, sir. All right, then with that, I will have the looks like Attorney Upper has some issues she wants to raise.
Yes, I just have one question, Your Honor. Would I have permission to put the easel up and display some of the poster boards? I did confer with Captain Dussault as far as security is concerned, and he agreed to it if the court would give me that authority.
Where would it be displayed?
He's gonna put it like right here, and then you want me standing at this table during
I do.
Yes, so I would just position it like right here. And I don't have to leave it up through the whole thing. I realize it blocks the view of people in the courtroom. Detective Casey would be willing to assist me in removing them when I'm done with them, if that's okay with you.
I trust it won't block Mr. Brooks' view of the jury, and
That's
as long
what I-
as,
Yeah, I was gonna put it right about here so that he can still see me and the jury.
with that caveat, yes, I will allow that.
All right.
Objection, what is that? What is supposed to be put up?
They were previously admitted, Your Honor. It's Exhibit 15 and 130, I believe.
So are they exhibits? I'm confused to what they are.
Mr. Brooks, I've made a ruling, the state has made a request, I've granted it.
Yeah, but
In
I'm
terms
saying,
of-
I don't understand what's being
It doesn't
shown.
matter.
Should not have the right to ask, to object and ask what it is that's actually gonna be shown.
It doesn't
States
matter
put
if
on the
you
record what it
understand.
is, they are exhibits that have previously been received by the court during the course of this trial. That is proper for a party to do that during its closing arguments.
So
Which
can
you
I
would
put up
know if
exhibits?
you knew anything about
Um,
being a lawyer, or the law in general, as it were.
Mr. Brooks, I don't know what you have planned for your closing argument, so.
I'm making a request, the same request. May I be able to put up,
Well, I guess it
exhibits?
depends on what it is, sir. So I'm not gonna take up any more time, because what I intend to do is, once the state goes through its closing, I may take just a short comfort break, depending on how long it is. And if there's something in particular, what are you will need to tell me what it is. As long as it's an exhibit from this case, then I wouldn't have an issue with it.
I bet they're gonna be.
They would be from this case, obviously. It's just not nothing that the state has.
I'm not aware of exhibits that the state wouldn't have, that you would have. Everything that's been received, we have a list. So if it's not something that was received during this trial as an exhibit by the court, unless you tell me what it is so that I can make a ruling, I can't see how it would be relevant or appropriate for your closing argument.
They're part of my filings that you filed.
The filings have no relevance to the issues that are before the jury. The closing arguments are to direct the jury so that they have your arguments, so that when they go back to determine the issues in this case, which are related to whether you're guilty or not guilty of the 76 charges, things like subject matter jurisdiction or like that would not be something that would be proper before this jury. Those are legal issues that the court would decide. The jury is the judge of the facts. The court is the judge of the law. That's why I have all of these jury instructions to give to the jury.
I'm not referring to subject matter jurisdiction.
What are you referring to then? Be very specific so I can make a finding and ruling.
I was specific, my other filings that was
That's not
filed.
specific enough,
My-
sir. What are you referring
Court
to?
docket
Which
sheet,
filing?
let me know when you're done, Your Honor.
Which filing, sir? Not generally, but specifically.
Are you done? Are you
Unprecedented.
done?
Sir, that's very rude and
I
disrespectful.
didn't know if you was finna say something.
I
That's why I'm
paused.
asking, are you done?
Which, what filing
Your
are
Honor,
you
how
referring
come
to?
every time I try, even when I try to err on the side of caution, you find some way to make it to be something that it's not. I didn't know if you was gonna say something else.
I've asked a question, sir, so when I do that, I hope it would convey to you I'm looking for an answer. So which filing are you referring to?
All my filings, my notice of appearance, my statement of particulars, my bond, the court docket sheet, all of those filings.
The request to display those to the jury is denied. It's not relevant.
How is it not relevant? Not even your
That's my
oath of office?
determination, sir, so I am going to start this.
Not even your oath of office can be shown?
No, that is not relevant to these proceedings, sir.
It is.
It's not relevant in front of the jury.
Why is it not relevant? Can you
Mr. Brooks, you
explain
are
why
not
that's
going
not
to
relevant?
be able to raise those types of issues and present a closing argument based upon my oath of office, whether I'm licensed to practice law in the state of Wisconsin.
I said your oath
whether
of
there's
office. I didn't say
subject matter
anything.
jurisdiction, whether you consent to this appearance or not. None of those things help the jury determine the issues in this case, which are related to whether you are guilty or not guilty of the 76 charges that have
The
been
jury
filed
should
in
know
this
that
case.
they should know the truth in their duties, in their rights. They should know that at least.
Mr. Brooks, I'm putting you on notice that if you continue with this insistence upon presenting information that's not properly before the jury as evidence in this case, that I will instruct you during your closing argument to move on and potentially ask the jury, have the jury leave so that I can admonish you. And if you keep insisting on that, sir, that will be in direct violation of the court's direction
So
to
they
you.
can't even know that I got a shock device on my ankles?
They absolutely do not need to know that.
Why
so
not?
It's not relevant to the determinations of guilt or innocence in this
It's the
case.
truth.
Mr. Brooks, your custodial status is not on trial here.
I would argue that it
Your
is.
conduct from November 21st of 2021 is
That
what's
hasn't
on
been
trial.
proven.
You may not bring up the way that you've been shackled. It's not relevant, sir.
It's
and if
the
you
truth.
do so, you do it at your peril. But here's the
There
thing:
is
the
no
jury
peril.
is specifically.
It's my right,
no,
though.
Let me go. Okay.
It's my constitutional
is-
right. Just
There
like
are
under the
certain
First
things
Amendment,
that
which I
you're-
preserved my First Amendment right when I came in this morning, I also preserved my
Right.
Sixth
Mr. Brooks,
Amendment right.
please stop. You do not have an unfettered First Amendment right. That is very clear based upon.
What do you
all
mean
the
by
case law.
unfettered? What do you mean by unfettered?
It
I
means
don't.
it is not absolute. It can be restricted.
So the Constitution of the United States can be constricted.
All right, Mr. Brooks, I'm putting you on notice that if you continue with your insistence on raising issues that are.
I'm going to
merely
raise
of
issues that the
abstraction,
jury needs
that
to
are-
know,
They're not
regardless,
issues.
because they're under the rights of the United States Constitution, which
Mr.
is the
Brooks,
law
I
of the
direct
land.
your attention to closing instruction 460,
I'm
which will
going.
be
I'm
read
going
the
to
jury
let the
at some
jury
point.
know the truth, their duty and their rights. Under the First Amendment and under the Sixth Amendment, I have the right to inform them of their rights, of the truth, and of their duties. Under the First Amendment and under the Sixth Amendment of the Constitution of these United States. You can't. No state law can override that.
Mr.
Any
Brooks,
law,
do you intend
any
to
law
keep this up when the
repugnant.
jury comes out?
Your Honor.
Because I need to
No, I
have
do
the
not. That's
state-
why I'm addressing this before
not-
they come out. That's why I'm trying to address this before they come out, so it doesn't become an issue once they're in here. But under the First Amendment and under the Sixth Amendment of the Constitution, which are rights that I preserved the moment we stepped in here this morning when this proceedings started, I preserved those rights for the record. And now you're telling me that those rights are not, would you say unfettered or I don't know what you say. I don't even know what that means. I don't even understand that. But any law repugnant of the United States Constitution is null and void.
Mr. Brooks, I'm putting you on notice that you can also forfeit by your conduct the right to present a closing argument. In appropriate circumstances, the right to present a closing argument, no different than the right to testify, may be subject to forfeiture where your conduct is incompatible with the assertion of the right at issue. The goals that this court has attempted to follow throughout this proceeding are multifaceted and multifold. Number one, I do have an obligation and have done my best to ensure that this is a fair trial. However, a fair trial does not mean a defendant has unfettered rights to state whatever he wants, when he wants. This court, not only through the course of the trial, is deemed with the responsibility to control the presentation of evidence so as to ensure fairness and reliability of the criminal trial process. It also includes ensuring that the closing arguments are relevant, are appropriate. This court must also be concerned with efficiency and effectiveness, and of course, last but not least, courtesy and decorum in this courtroom, what I would generally refer to as civility in the courtroom. You do not have unfettered First Amendment rights or an unfettered Sixth Amendment right, sir. You must conform your conduct to the rules of decorum, the rules of evidence, and the rules of procedure. While you have a right to present relevant and probative arguments to this jury, You may not. And you may not present arguments related to such things as jury notification, subject matter jurisdiction, the court's oath or lack thereof, if that's what you believe, whether this court is a court of common law, admiralty, all of those things relate to your claim as being a sovereign, which are frankly baseless. They're meritless. They've been debunked by many courts, including the court in the Beneby decision that's been referenced by this court previously. I will give you a fair opportunity to present a closing argument, but again, it is not unfettered. The simple fact is, sir, this court can restrict your right to present a closing argument. This court has the authority under 906.11, under the various cases, including Illinois versus Allen, including Rock versus Arkansas, although Rock versus Arkansas and Chambers versus Mississippi dealt with the right to testify. There is a decision, I looked it up earlier, and I'll just pull it up and tell you the case site so that you have it. I would direct your attention to Herring versus New York, found at 422 U.S. 853, a 1975 case, although in a footnote.
It's like how to get free law school.
It does stand for the proposition that a defendant who has exercised the right to conduct his own defense has, of course, the same right to make a closing argument. That's quoting Ferretta versus California, or following the same logic from Rock and Anthony and Chambers, a right, even a constitutional right that a defendant has may be forfeited by conduct. This court, just like it attempted to do with regard to your right to testify and set up reasonable restrictions so as to meet all of the goals that the court needs to meet, will be as follows, and that is, again, sir, you may not bring up matters that are not relevant to the determination of guilt or innocence. That means evidence that was not presented and not received in this courtroom is not relevant to your closing arguments. It's not, the arguments must be based on the law, not as you interpret the law, but as the law is. You must base your closing arguments on the facts that have been established during this case, meaning the evidence, the testimony. As I indicated earlier, the purpose of a closing argument is to summarize the facts, marshal arguments, and focus the issues for the jury. It is fair that you comment on evidence, including arguing evidence to the conclusion or inference. It is your ability or your opportunity to convince the jury that you are not guilty of these offenses. You may not convey any idea that you have undisclosed information. Neither party may vouch for a witness or otherwise express personal belief or opinion regarding truth or falsity of any testimony or evidence. It would be improper to ask a jury to draw inferences that the parties know are not true. And your comments on evidence is limited to evidence in the case. You may not comment on facts outside the record or peculiarly within your own knowledge. And that is just some of the guidelines for determining the proprietary of arguments that I am guided by from my judicial bench book and all of the cases that are referenced therein. So you are put on notice, sir, that even without an objection, this court may, in an effort to preserve the dignity, the decorum, and to keep the issues properly before the jury, may advise you during your closing argument to move on. If you do not honor the court's rulings, then you will run the risk of forfeiting your right to be present and potentially forfeiting your right to further present your closing argument. With that, I am bringing this jury out to complete the instructions that I need to complete, to add to the credibility instruction the paragraph on implicit bias, and to let them know the full instructions that they receive will have
just gonna wait till they're
to
coming
read
out,
160
sir.
closing arguments of the parties, and then to have the state go first as they bear the burden of proof.
Now, Your Honor, I just let you make your record. I
Maybe.
didn't overtalk you. I didn't interrupt you.
Never mind.
Is that fair to say?
I take it back.
I'll let you make the record. With all due respect, when will I be able to make the record? As I've tried to do numerous times by saying I wanted to present an offer of proof for my appeal. That's the chance for me to be able to make the record.
I'm denying your request to make an offer of proof regarding your appeal. It's
So,
not, I am
I'm
not
not allowed to
required
make
to
the
give you
record at
that
all, Your Honor?
opportunity, sir.
I'm not allowed
Sir.
to make the record at all. As I just let you did, because some of the
Sir,
issues
I
has
have,
been some
you
of the
have
issues
told me
has
what
been
you want to
What
do,
do
I
you
told you
want?
you can't. I've addressed the
Your Honor,
request.
some of the issues have been me overtalking you and interrupting you. I did not do that. Even though everything that you said You have not proven for the record, and it's unlawful law. You haven't shown one time that is lawful for you to do what you've been doing as
Mr.
far as
Brooks,
your rulings.
once again, I'm not going to debate with you the prior rulings of this court. There's absolutely no need at this point for you to make
Your
an
Honor,
offer of proof regarding my prior rulings or decisions that you disagree with.
Your Honor,
you will have an opportunity, if convicted, to raise
the jury.
every issue you want on appeal.
I'm going to inform the jury of the truth, their duties, and their rights, as I have the right to do under the First Amendment and under the Sixth Amendment. You can't just disregard the United States Constitution. You can't do that. Again, any law repugnant of the United States Constitution is null and void. There's no state law that you can cite. There's no federal law that you can cite that overrides the United States Constitution.
Mr. Brooks, I direct your attention to State versus Anthony. Although that case dealt with the right to testify.
Okay, so we're not talking about the right to testify. We're talking about the closing arguments, correct? We're not talking about testifying, which you already made a ruling on.
I'm not going to delay.
You already made a ruling on.
But Your Honor,
with all due respect,
I will address your further request.
With all due respect, you already made a ruling about testifying. Did you or did you not?
Mr. Brooks.
So we're talking about now. We're talking about closing arguments that I said it's my right to be able to inform the jury of the truth, their duties, and their rights. That is my constitutional right.
Mr. Brooks,
you
we
can't
are at the
tell
stage
me
of the
I can't.
proceedings where it is the state's burden of proof, where they get to make their closing arguments.
We're talking about me though.
I understand that, sir, but
I'm going to inform them of the truth.
Right now is delaying.
I'm not intended
the court's
to delay anything. I let you, Your Honor. I just sat there and let you make the record. I didn't overtalk you or interrupt you. I let you say what you wanted to say. I let you make the record.
You let her. That's not how that works. But
I didn't interrupt you not one time.
No, but sir, you're attempting to disrupt the proceedings
by
going
not
off on a
attempting to
tangent
disrupt
into
anything.
all of these other issues. From my perspective, that is in an
how am I being
attempt to
dishonored?
simply
How am I being
delay
in
what we're
dishonor?
doing.
How am
So
I being
you
in
are put
dishonor?
on notice.
Right now you're interrupting.
Done dealing
How
with
am I
these
being in dishonor,
issues.
Your Honor? How am I being in dishonor of the court?
Mr. Brooks, I've made my determination.
And have I not preserved my rights?
This further.
Have I not preserved my rights?
If you insist on interrupting the court and disrupting the flow of these proceedings by a blatant disregard for the parameters that I've set up, you will forfeit your right to be present in this courtroom and potentially forfeit your right to present a closing argument.
Under what lawful law can you do that?
Sir, I've
You
made my
can
determination.
hold me in contempt by Illinois versus Allen. You can do that. You stated that numerous times.
Mr. Brooks, I want you here for the closing arguments.
Apparently
but
you
do
don't.
not
Apparently
want to
you
follow
don't, Your
the
Honor,
rules.
because all I said was it is my right under the First Amendment and the Sixth Amendment to inform the jury of the truth, their rights, and their duties. I never once said anything about, I'm going to bring up subject matter, or I'm going to bring
You're
up
right,
this,
sir.
or
And
I'm
I
going to
will
bring
wait
up
and
that.
see what you have to say, but I thought it prudent, given your conduct to date and your insistence on bringing up issues that have no bearing in this case.
This is a new
They're
day,
not
though, Your Honor.
relevant.
This
They're
is a
not-
whole new day.
That it was prudent on my part to give you some guidance before you potentially do that in front of the jury. But
Okay,
you're right,
but-
I will wait and see.
Your Honor, it's
But
still,
I need to get going.
it's still
and I'm going to,
unconstitutional for you to
sir.
tell me that
You
I don't
need to
have
be
the First
quiet.
Amendment right that I preserved, or the Sixth
Mr.
Amendment
Brooks,
right
I'm
that I
going to have
preserved.
the jury brought out. I expect that you will be respectful, courteous, and quiet.
Or I'll be
And
held
when
in
this door
contempt.
opens,
Or I'll be held in
if
contempt.
you insist on making remarks, then I will excuse everyone from this courtroom and you will be removed because you will forfeit your right to be present for being disruptive.
Under what lawful law?
That
Because
is
I
my
haven't been
ruling.
dishonorable to the court.
Madam Clerk, please have the jury brought out.
Well, take me to the next courtroom then. Take me to the next courtroom, because you're not going to override my constitutional rights just because you feel like you can, and you don't have no lawful law to do
you
that.
don't understand your.
We all have constitutional rights, and you cannot trample
Mr.
on
Brooks,
those.
what you are raising are essentially issues that you can raise on appeal.
No, I'm raising them now because they need to be on the record now. Because you won't allow me to make the record, as I've let you do. You even went so far as to mute
Mr.
me,
Brooks, the
which you
jury
can't
is
even.
coming
There's no
out.
lawful law to say that you
I'm
can even
advising
mute
you
me.
to be quiet. They're coming
Your Honor,
out.
does Illinois versus Allen say that you can utilize the mute button? It does not.
Mr. Brooks,
So
when
you're-
the door
you're-
opens, I expect you to be quiet.
You're,
you will
you're,
forfeit
and I
your right
expect
to
for
be
you to,
present.
I expect for you to answer questions as a public servant, Your Honor. You're a public servant.
jury's coming
You're
in.
supposed to serve the people.
All right.
Take me to the next courtroom, please. Take me to the next courtroom. Hold me in contempt. Hold me in contempt. Hold me in contempt. Hold me in contempt. I have constitutional rights that are being trampled on, and you're coming up with ways to make a lawful law where it doesn't say in Illinois versus Allen anywhere about utilizing the
Records
mute button.
reflect that the jury bailiff is in here. However, the jury is still in the hallway. I'm going to give Mr. Brooks one more opportunity to be respectful of the court's rulings, whether
Your
he
Honor, I
agrees with them
I
or
haven't
not.
dishonored the court. I'm merely exercising my rights under the Constitution, under the First Amendment, and under the Sixth Amendment.
Mr. Brooks, your rights do not include you disrupting these proceedings
I'm
the way
not
that you have
disrupting
through
the
the course
proceedings.
of
You just
3
told me
weeks.
you don't have to honor my constitutional rights in so many words. You're using a mute button
Mr.
that's
Brooks,
not
the
even in your
jury is
decision.
outside this door. They're not brought in
I'm
yet.
informed that
I'm
the jury. I'm
asking
informed
you
that the jury
to
is
be
outside the
respectful
door.
of their time.
They're not in the courtroom.
I'm
They're not
asking you
present.
to be respectful of the court's ruling,
They're
whether
not
you
present.
agree with
These
it
are
or
issues
not.
that need to be resolved before they're present.
Mr. Brooks, they will not be resolved to your satisfaction.
It's not about my
The record
satisfaction. It's
has
about the
been made.
Constitution. It's about what's right.
Are you going to
Are you
follow
going to
the
answer
court's
questions as a public
framework?
servant, or while you're making up laws that are not in the Illinois versus Allen? It never utilized
the
the
jury
mute button. It
can go
never
back
said
to the
anything
jury.
about a
Thank
mute
you.
button.
It is clear
Why
that
am I
Mr.
being
Brooks has
muted?
absolutely no intention of following the simple rules of decorum and courtesy. He has repeatedly talked over me. He's repeatedly interrupted. Even though I've made rulings, he's not respectful of the fact that I made a ruling, even though he disagrees with it.
How can
I
you
Remove his
attempted to
ass.
bring the jury out,
How can you
and
utilize a mute
he
button?
continued to talk.
That's
So, Mr. Brooks, you
Your
have
Honor,
forfeited your right to
is
be
that-
present for the state's
is that
closing
not-
argument.
Your Honor,
You will
can
be
you answer
taken
this
to
question?
the courtroom next
As a
door, and I
public
will
servant,
invite you back over when it's time for your
you
closing
can't invite me
arguments.
back over. I can reclaim my right. So how can you invite me
All
to
right,
do
the
anything?
courtroom is to be cleared so that Mr. Brooks can be removed to the next courtroom, and I'll make appropriate findings when he's in the other
Yeah,
courtroom when I can
and
do
you'll
so
mute me, which you
without
can't lawfully do.
interruption.
You can't lawfully mute me. So now you're trampling over my First Amendment.
Bye. What do we got? Shaking the spindly fingers at the TV screen.
Rules of evidence, the rules of procedure, the rules of for me to make my ruling constitutionally permissible way we want them. Income level, or any other personal characteristic. Consider carefully the closing arguments of the parties, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. With that, I will ask Attorney Opper to start with her closing argument. Go ahead.
And then, clerk, if you'll please turn on the PowerPoint.
Yes. Hold on one second. Mr. Brooks,
I thought I was supposed to be unmuted.
you are now.
I
Nothing's,
thought I was supposed to be unmuted.
you are now. All right, Attorney Opper, you may start.
Thank you, Judge. Good afternoon, everybody. Kind of nice to stand here in the middle of the courtroom. You know, all week or the last 3 weeks, they shoved me at the end of the table because I'm the lefty in the group. It's nice to be able to look at you all and say thank you. Truly thank you. Each and every one of you. I want to express our sincere gratitude from the prosecution team, myself, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Woodshow. There's no one in this courtroom that does not realize the sacrifice that you've made serving your community in this very important task. You've put your lives on hold. I don't even want to hear from your bosses. Thank you. You've watched these proceedings and you've noticed as we sit at our prosecution table, we don't have a client at our table. But rest assured, we do represent someone. We represent the people of the state of Wisconsin. It's an entity. I can't bring it to the courtroom. People enact laws. People want to feel safe. People have representatives in Madison or Washington, D.C. that set standards, rules that we all are expected to live by. And when those rules are violated, prosecutors step in and enforce the law. Darrell Brooks does not represent anybody. He does not have a client. Darrell Brooks is the client. Darrell Brooks is the defendant. The state of Wisconsin is the plaintiff. It's really that simple.
That's
And it's
simple.
any other criminal case you've ever heard about at any other time in any other jurisdiction. It runs the same, no matter what state or federal. I'm going to ask you for your guilty vote at the end of my comments. It's up to you. I can't tell you to do anything, except I'm going to say one thing to you that I wholeheartedly ask you to obey.
Attorney Opper, I'm sorry for the interruption. Your objection, sir?
mischaracterization of who I am and the way it was said. I feel like it was talking down.
All right, your objection's noted. It's overruled. The state may continue.
You must not consider anything about Darrell Brooks other than his conduct in downtown Waukesha on the evening of November 21, 2021.
Look what they did for you.
Nothing he's done before that, nothing he's done since that.
Look what they did
When you
for
go
you.
back to that deliberation room, please obey Judge
And of
Darrell.
course you're gonna object.
Confine your comments to his conduct on November 21 of 21. Is he guilty of the 76 counts that he's been charged with? That and solely that should be your topic of discussion. So, what are the charges against Darrell Brooks? Thank you for your patience in listening to the jury instructions. They must be read for each and every count. But sadly, they can be summarized very quickly like this as far as the actual counts. Counts 1 through 6 are first-degree intentional homicide while armed with a dangerous weapon. Counts 7 through 67, first-degree recklessly endangering safety while armed with a dangerous weapon. Counts 68 through 74, hit and run causing death. Counts 75 and 76, bail jumping, and count 77, battery.
Whoa.
Mr. Brooks, what is your objection?
I have 76 charges, not 77. It's mischaracterization of the charges.
That is correct. It is sustained. It should be count 68 through 73, I believe, and then 74 through 75, and then 76.
Thank you, Your Honor. I do apologize for my math skills. 68 through 73, 74 and 75 are bail jumping, and 76 is battery. I apologize for that misstatement. We're going to talk about counts 1 through 67 in detail. Counts 68 through 73, hit and run causing death, in my opinion, are easily summarized as this. He never stopped. Never. Bail jumping, he was out on bail for 2 files in Milwaukee County, facing felony charges there. He was ordered to not commit any further crimes. If you believe he was involved in any of the conduct charged in counts 1 through 67, you should find him guilty of bail jumping. Battery, that relates to the split lip and black eye suffered by Erica Peterson. We told the story kind of backwards. We started with the battery for background. First degree intentional homicide. You've seen this in our opening statement. You've heard it from Judge Darrell. Did Darrell Brooks cause the death of the victim, a victim? Did he act with intent to kill, meaning either the mental purpose to take the life of another or was aware that his conduct was practically certain to cause the death of another human being? Count 1, Ginny Sorensen. Count 2, Lee Owen. Count 3, Tamara Durand.
Oh, I got some.
Count 4, Jane Kulik.
Thank you.
Count 5, Bill Hoskell. Count 6, Jackson Sparks. Those are the individuals who lost their lives because of the conduct of Darrell Brooks. From there we go to reckless endangering safety. What is that? In this case, it means that through his reckless driving, he endangered the safety of other people. And he did so demonstrating utter disregard for human life. Now, behind me is State's Exhibit 15. It's also on the PowerPoint. If you choose, you may have this chart with you in the deliberation room to help you walk through each of these counts if you find it helpful. It's up to you. If you don't want it, you don't have to have it. But it will be available for you if you ask for it. And it'll take you, as we did in our presentation of the case, right down Main Street and address all the counts that were involved, all the counts that were charged. To prove reckless endangering safety, and I'm just going to go back one slide, nowhere do you see there that we have to prove any degree of injury to anyone. Never once did Judge Darrell instruct you that somebody has to be physically injured. Now, Detective Casey told you that was the standard we used in deciding of all these hundreds of thousands of people who is included in these charges. And a decision was made by the prosecution team to include people who were physically injured, to be efficient in our prosecution. And so everybody up and down the street, I would argue, had their safety endangered that day. I didn't charge 5,000 counts. We selected 61 counts of people that we can identify by name in Exhibit 15 that were injured by the conduct of Mr. Brooks. Those are the people in green. People in red are the fatalities. And we presented this case to you in much the same fashion that is presented here on Exhibit 15 as to how the injuries occurred going down that street. So we are absolutely held to our burden of proof and the elements for each offense that Judge Darrell instructed you on, but we are not required to prove any injury to anybody. The question is, was their safety endangered by his reckless conduct, his reckless driving? Now, some of the groups, it's pretty easy. They walked in a formation, and you can get a photograph or a diagram, and you can kind of see pretty easily who was located where, right? And you can think back to the videos that you've seen for each of these groups and remember, and you'll see them again, the path of the vehicle as it went through each of these groups. This is South Band, of course. All of these names that are being displayed on the PowerPoint Exhibit 21 are on Exhibit 15 in green for Waukesha South Band. Pretty much the whole left half of the formation was endangered by the safety of Darrell Brooks driving up the side of that band. The extreme dance team, it's a little difficult to read, but again, this chart was marked as an exhibit. It's exhibit number 33. If you want it, you can have it in the jury room. The names on this chart will match the names for the extreme dance team on State's Exhibit 15. All of the girls that were struck and injured as they marched with the extreme dance team, plus some people on the back that were handing out candy or serving in support roles as the unit made its way down the street. The Dancing Grannies, State's Exhibit 54, the formation that they marched in, who was located where, and your recollection of how that SUV zigzagged through that group. And you can just see the names and match it up to who was injured and killed versus who wasn't. Now, one of the big things in this case has always been, why did this happen? What was he thinking? Why did he do this? Again, those are things I don't necessarily have to prove to you. His intent, I do have to prove, and I submit without any doubt there's overwhelming evidence that this was an intentional act by Darrell Brooks and an act of utter disregard for human life. I say that for these reasons, folks. Number one, first and foremost, just stop driving. That's it. It's really that simple. Not one person had to be hurt that day if he would have just stopped driving.
Excuse me, Attorney Albert, your objection, sir?
You specifically, I'm sorry, can I be heard?
Your objection, sir?
I didn't know if I was on mute or not.
You're not?
You specifically said in your jury instructions that intent cannot be, you can't look into someone's mind, I think is what it says, to find intent. So how could that be characterized as someone knowing for sure intent or not knowing for sure intent?
You're making an argument. You'll have an opportunity to do that later. Your objection's noted. It's overruled. The state may continue.
I apologize.
We showed you at the very beginning, remember our first witness was Sergeant Warner, the man who was the incident commander for the parade. We put up another map. I think it's State's Exhibit 1. You can have that if you want it. Shows all the positions of all the police officers and the reserve officers, the barricades, the squad cars. How do I know it was intentional? Because even Darrell Brooks told Detective Carpenter, I could tell something was going on downtown. No reasonable person would drive upon this area, see the squads with their red and blues on, see the officers in the street with their bright yellow vests, see all the people milling around, see the floats lining up and the participants getting ready and not know to drive safely, slowly, and obey officers. The barricades help us prove it was intentional. The police presence help us prove it's intentional. The parade participants help us prove it's intentional. And the parade spectators help us prove it's intentional.
Excuse me, Attorney Alper, your objection, sir?
Speculation as to what the alleged defendant said he saw. It
Sir,
was never.
your objection's noted, it's overruled. This is closing arguments, not the evidentiary phase. Go ahead,
So
Attorney
how can
Alper.
so how can speculation be made to what was saw? if
Your
that was never
objection's
testified
noted,
to?
it's overruled. Continue, Attorney Alper.
Honking the horn. Quite interesting that Mr. Brooks asked so many witnesses if they heard the horn honking. Some of them said they did at the beginning of the parade. Yeah, I heard a horn honk. Most of them said they didn't. The horn honking cuts both ways, folks. If he's honking his horn, that means he can see something's in front of him. That means he knows there's an object in the road. You can rely on your common experience in your affairs of everyday life. If you see something in the road and you want to alert the other person to your presence, you will honk. But you do not have the green light to then just keep going if they don't move. He knew they were there. Intent. I've skipped one, I'm sorry. Going back to my street, number 15, I failed to include the Catholic community. That's just one of the photographs showing the people that will match up to Exhibit 15 from the Catholic community of Waukesha. There's a lot of photographs identifying the people that were marching with that group. The parade started. This is the starting point, or at least near the beginning, right? This is the area. We showed some videos of the groups passing by in this area. We heard testimony from 4 different police officers standing in 4 different spots near here, telling of their 4 different efforts to stop him. Intentional. Sergeant Wanders back here testified that this red SUV blew by me. I waved both arms over my head. I'm in a police uniform. I have an unmarked squad, but I have my red and blues on. And he blew past me. He gets down here to the corner where Detective Casey is standing. Detective Casey runs out into the street, gets close enough to put his hand on the hood of the car. He keeps going. He comes down, turns onto Main Street, gets in this area of East Avenue to the south and Buckley Street to the north. This is where he encounters Officer Schneider and Officer Buttrin. They each make a separate effort to stop him, and he keeps going. 4 police officers. It's intentional. He had plenty of opportunity to just stop anywhere along the way. One of the officers testified to it. I think it was Officer Schneider. If this was an accident and he mistakenly wandered onto the parade route after passing all this, and he mistakenly wandered onto the parade route at any point, all he had to do was stop. They could have paused the parade. They could have moved the barricades and escorted him out. He didn't. It was intentional. He went on for 4 blocks. 4 blocks. It was intentional. He reached speeds of approximately 30 miles an hour. That's intentional. He plowed through 68 different people. 68. How can you hit 1 and keep going? How can you hit 2 and keep going? How can you hit 3 and keep going? Didn't faze him a bit. He kept going until he got to the end, and there was no more bodies to hit. It's
Your objection,
intentional.
sir?
Mischaracterization of the evidence.
Noted, overruled.
His conduct when he left the parade route, we'll get into this. His flight, his hiding, his panic, his desperation to run. Get the hell out of town as fast as he could before the cops came. That shows his intent. His interview with Detective Carpenter, we spent several hours playing you snippets of that interview. How telling was that? Never once did he say any of these things. Never once did he say, like he told you in his opening statement, it wasn't an accident, it wasn't intentional. Never said that to Detective Carpenter. No, he came up with some convoluted story about I got a ride out here from a buddy in a tan Kia, and then I left to go meet Erica, and we got into a fight, and then I went back, and the other guy got into a fight, and he was leaving, so I took off on foot. Absolutely nonsensical story. Does not match up with the known evidence in this case.
Overruled.
He never
I
stopped.
didn't even state the objection.
This is closing argument. She may continue.
I'm going to play this slide, which is a snippet from State's Exhibit number 53. Go ahead and play with sound, please. That was just a snippet that I selected because I thought it really captured the environment that so many witnesses tried to explain to you, right? It's a Christmas parade. People are there with their families, their little kids, their grandkids, their neighbors, their friends, strangers, standing next to strangers. That's what's going on Main Street. While that's going on Main Street, this is going on. Remember this? This is the gas station on the corner of Barstow and North Street. While the units are marching down Main Street, entertaining the crowd, Darrell Brooks is driving recklessly. He's enraged, and he's arguing with Erica Patterson. Why is this important? This is important because before he even gets to the parade route, this is how he's driving. He drives the wrong way down North Street and then acts like it's everybody else's fault in the world.
Your objection is noted. It's overruled. You may continue, Attorney Opper.
When he finally pulls into the gas station, he rolls down his window and yells at the driver who's properly stopped at the stoplight that it's somehow that guy's fault that Darrell Brooks is trying to drive the wrong way down North Street. And from there, the rage continues. We get to this point, State's Exhibit number 3. Please play. The video is playing. You can see the pushing match between Darrell Brooks, Corey Runkle, Erica Patterson, and Nick Kirby. Watch this. He turns to get in the car, flips up his hood, and goes and gets in the passenger seat. I'm sorry, driver's seat.
How long we gonna mischaracterize testimony?
Sir's argument. I've heard nothing improper. Your objection is noted. It's overruled. You may continue, Attorney Opper.
Thank you.
They need to know they can nullify.
That's it. He drives off onto the parade route. From this moment, right here on Exhibit 15, you're watching it. He's enraged. He's angry. Flips up that hood, and he zooms past Sergeant Warner, past Officer Casey, onto the parade route. Now, there's no doubt, for the first 2 blocks, he does not strike anyone. And as we've discussed, some even said he was driving at a reasonable speed initially. By the time he gets past Officer Buttrin and Officer Schneider in this area here of East Avenue, past East Avenue, and clearly once he gets past Barstow, that's where it starts, right? That's where it starts. Nicole White, our first victim, walking with Remax and hot air balloon. Knocks her over, keeps going, runs up and over the backs of Waukesha South Band, hits the green children spectating on the sidewalk, keeps going, runs over Kelly Grabo and her daughter Adelia, walking with Burris Logistics, keeps going, plows through the entire extreme dance team just before the 5 points, keeps going, hits Deborah Ramirez and her son Isaac spectating on the south side of the street, keeps going, clears the 5 points area, hits Jane Kulik square on, causing her to go up on the hood of the car, and then fall off and drives over her body. He doesn't stop. He keeps going. Runs through the kids over by the steaming cup. We heard the parents testify about little Brinley and Kelsey and Owen that were standing there outside the steaming cup. They were struck by the red SUV driven by Darrell Brooks. Keeps going. Plows through the grannies in that zigzag fashion, striking most of them, injuring them, killing them. Keeps going. Gets down here to the end and goes through the Catholic community. The witness, remember Holly Berg? She testified about that mobile gas station incident. She said she was standing down here in this area. She said, I saw 15 to 20 people fly in the air. They looked like bowling pins. And when she saw the video, she's absolutely right. It's a terrible description when you think these are human beings, but that's exactly what it looked like. When does the intent exist? Doesn't have to be even for a second. I'm not telling you who set out that morning to cause this carnage. But when he became enraged back here, he didn't give a damn who or what was in his way. He intentionally went on. I'll show you. Motive. I don't know why he did this. Folks, I don't know why. Other than the rage. He's right. You cannot read minds, neither can I. But the law doesn't require you to. The law gives you a way to reach a conclusion as to what is somebody thinking, and it's right here. Decide it based on his acts, words, and statements, and from all of the facts and circumstances. I've already been through many of them. I want to show you what I mean. Look at this. Was there room for him to get out? This is way back at the beginning. This is Officer Buttrin's squad video. Way back at the beginning. That's Buckley Street here that you're looking at. Look at those barricades. Look at the sparse crowd. And there's Officer Schneider in her yellow fluorescent vest on the left side of the picture, about to run into the street and stop him. Intent. I'm going to play this video for you because, folks, for me, this is where it becomes crystal clear. You watch this video, the first thing you're going to see if you direct your attention to the left side of the screen is you're going to see him hit Nicole White. Knock her to the ground and keep going. Now, if that was the end of the story, you may sit here and say, Madam DA, I don't know how you conclude intent from that. Maybe it was an accident. Maybe he didn't mean to do it. But watch what happens in this video after he knocks Nicole White down and tell me this does not prove intent. Please play. Keep watching the left side of your screen.
Oh my God. Oh my fucking God.
That's intent, folks. No reasonable person is going to come across a group of teenagers playing band instruments, drive over them, and keep going. That's a still shot of the same thing. That's intent.
Objection, sir.
How can you tell the jury what they supposed to think?
It's proper argument. Your objection's noted. It's overruled. You may
I would
continue.
argue that it's,
Attorney Alper.
I would say that it's improper, and I move
Mr.
for a
Brooks, I've made
mistrial.
my ruling. I'm going to mute you if you don't follow the rules.
Exhibit
I move for a
1,
mistrial.
Exhibit 152.
Did you say I moved for a mistrial?
Clearly intentional conduct. Clearly intentional conduct. States Exhibit 93. We asked the court to take time to have you go look at this car in person because it's remarkably amazing that this damage was caused by human beings. That's intent. This is an excerpt from States Exhibit 154. Maybe a little hard to see. A lot of that laying in the front part of this photo are shoes. Remember what Dr. Vidritsky said about the shoes, the
First
feet,
thing
the
comes
scuff
off.
marks on the toes and the ankles? Look at all the shoes laying in the street. This is the area at the end when he ran through the Catholic community. All the shoes laying there because of the velocity. Remember, the medical examiner talked about the velocity. It's not just the speed, it's the velocity. The power that these people were knocked right out of their shoes.
Right out of their shoes. Yeah, that happens.
That's intent. The flight, the hiding, changing his appearance. He had to go through some effort, right? Crawled up in this playhouse, ditched his sweatshirt and his sandal. The other sandal seems pretty reasonable. He dropped it when he was jumping over a fence. Changed his appearance. Please play.
Excuse me.
Intent. What's he running from? What's he running from if he's just a lost guy with no ride back to Milwaukee? What's he running from as there's cops, sirens wailing in the background? Whoops, that was me. So, State's Exhibit number 130. Put that up here quickly. Take this. Thank you. I'm not going to go through this whole thing, folks. Suffice it to say, after Officer Skolton tried to stop the threat at that intersection at the top, Wisconsin Avenue.
Let her finish.
So I can rebut him?
Go ahead, Attorney Opper.
Thank you. I'm going to conclude my comments with this, folks. I'm going to show you the video, a stitched together video of all the carnage caused by Darrell Brooks, and I apologize.
Stitched together.
This is important that you know what he did.
But damn it.
It's important
Ugh.
that you think about the women like Nicole White and Kelly Grabo and her daughter and Jane Kulik, who were just there with friends and co-workers supporting a local business. The teenagers marching in the band, representing, wearing their school colors. It's important. The boys and girls with the Blazers baseball team and their coaches doing nothing more than handing out baseball cards. Imagine how they're in the street as he snuffed it out. It's time for Darrell.
Mr. Brooks, the jury has been asked to be brought out. I've requested
Value this document.
closing argument and then the final instructions to the jury.
I would hope it proves subject matter jurisdiction on the record too.
All right, I will instruct the jury to come out. For the record, the written decision is once again being provided to the
I accept
defendant.
for value and return for value this document as it is not based in lawful law. And it does not prove subject matter jurisdiction whatsoever. Refers to some complaint that was filed in the name of a trust, not my name. Were you aware of that, Your Honor?
Mr. Brooks, the jury has been asked to be brought out. I've requested that they be brought out. They're on their way.
Were you aware
Please
of
be
that?
prepared with your closing argument.
Were you aware of that, Your Honor? Or is that a tacit agreement that you don't have to answer any questions as a public servant?
All rise.
So that is a tacit agreement.
Record should reflect the jury is coming out.
This is gonna be ridiculous. Oh man,
Need to begin closing arguments.
So this is your opportunity to provide your closing argument to the jury. Thank you, everyone. Please be seated. Go ahead, sir. You may begin your closing argument.
I'm not ready to begin closing arguments.
So this is your opportunity to provide your closing argument to the jury. Please start. I've started the timer of 1 hour.
I'm informed of that, Your Honor, but I'm not ready to proceed as I don't understand the reason why the questions asked before the jury was present were not answered. There are issues that needed to be addressed outside of the jury, as you always say, which I don't understand why the jury deserves to
Mr.
need
Brooks,
to
this
know.
is your opportunity to present your closing argument to the jury. Please do so.
I'm informed of that, but the jury needs to understand the truth, their rights, and their duties, as they have not been informed of their truth, their rights, and their duties.
Mr. Brooks, the court has begun the instruction process. I read 73 pages this morning, and into the early afternoon, I have another 30-plus pages to read.
Did you inform
They will
the
be
jury?
informed of the law.
Did you inform them that they
Mr.
can nullify
Brooks,
the law?
Mr. Brooks, you do not have that right to request that. And
Were
I'm
they
advising
informed?
you, one more time, this is your opportunity to provide your closing argument. Please begin.
I intend to when ready. I just want to know if the jury was informed that they can nullify the law.
Mr.
they
Brooks,
are-
you
that
have
they
no
have
right
the
to
power.
make that argument to the jury.
It's true.
Again, you want them to nullify the law that it makes it legal for you to run people over because you don't like. Seriously, dude. Burn in hell,
They
dude.
have the power.
All right, I'm going to excuse the jury.
They should know that they have the power.
Please rise for the jury.
Unbelievable.
Mr. Brooks, you do not have a right to request jury nullification directly from this jury. I direct your attention to the Bjerkas case, Bjerkass, that's State versus 163 Wisconsin 2nd 549. While you are not incorrect that the jury has the power to nullify, they don't have the right to do so, and no party has the right to instruct or to request an instruction or to argue jury nullification. You may talk in terms of fairness in general terms, but you may not go further. You may not argue that the jury should discard the instructions in the law and find you not guilty for that reason. You may not use the phrase jury nullification. You've done that now at least 3 times in earshot of the jury. Twice while you were in the other courtroom, I was able to mute half of what you said the second time, and then of course you raised that once again while in front of the jury
Yeah, he's
just
gonna keep
now.
trying to.
You also indicated
Come on.
you weren't ready
He's
to
already
give your
told you he's
closing
gonna-
argument. Sir, the time has come for
He's already told you. He's already told you he's going to bring up whatever he wants to. He does not take instruction from you.
you to give your closing argument. If you choose not to do so at this time, then you will forfeit your right to present a closing argument by your conduct.
I haven't made any such choice, so you can't coerce me into.
We went over this at the very beginning, dude. We went over this at the very beginning.
Right, and I will not allow you as a public servant to do that. I have not made a choice.
Sir, the time has come for you to present your closing argument.
Are you making a judicial determination that you're denying me a constitutional right in
I have
open
not
court
made such
on
a
record?
determination as of yet, but you can forfeit your constitutional rights
Under
by
what
conduct.
lawful law?
Illinois versus Allen, State versus Anthony.
Illinois versus Allen does not reference anything pertaining to rights when talking about
In
closing
State versus
statements.
Anthony, the
Illinois
Supreme
versus
Court of
Allen.
Wisconsin referenced both that decision when it essentially extended the reasoning or adopted the reasoning of Illinois versus Allen to then find that a defendant could forfeit an important constitutional right by conduct. In State versus Anthony, it was not the right to be present in the courtroom, it was the right to testify.
Okay, so none
And
of
the
those that you
reasoning-
just named have anything to do with the closing arguments, Your Honor. You've used Illinois versus Allen repeatedly to when it comes to me being removed from the courtroom. Not one time did it bring up anything dealing with a closing statement or a closing argument. So how is that same statute being used for something that it doesn't even refer to or pertain to?
Mr. Brooks, the Allen decision, Illinois versus Allen, and the Anthony decision, which is State versus Anthony, are 2 examples of cases where a defendant lost a very important constitutional right because that right was forfeited by the conduct of that particular
And
defendant.
that was to be present in trial, correct?
The right to present a closing argument is no different. Because it is not evidence, it could be said that it doesn't even rank as high as the right to testify, which is guaranteed by the constitutions.
Which I was denied the
I'm
right
not
to
prepared to
be
make
able
that
to testify
ruling
to.
here yet today, but I will tell you this, sir. The time has now come for you to present a closing argument. There will be no further delays.
It's
I
not a
will not be
delay.
taking any further adjournments for you to prepare. You were advised yesterday that this court would proceed today with instructing the jury and with the parties making their closing
And you
arguments.
made that while
It is
violating
up-
my constitutional
Sir,
right.
please don't interrupt me, because
Well,
you've now
you did.
interrupted me a couple of times.
No, once. So let's make
Twice.
that correct. Once.
That's the third time.
Okay, now you can say
So, Mr. Brooks, I'm advising you yet again, the
I
time
don't
has now
consent to
come,
being called
that's
that name,
another
Your Honor.
interruption.
Shut
The
the
time
fuck
has
up.
now come for you to present your closing argument to this jury. You were
And-
brought back over to this courtroom for that purpose.
I'm going to let them
That's
know.
another interruption.
No, I'm going to let them know that they have rights and they should be told, informed of the truth. It's not me
Are you
trying to
telling
give.
me, sir, that
it's
you
not
not
trying
to
to
taking-
give.
dis-
He's
let
not
me ask
taking
you a
it.
No, hello.
question.
I'm not trying to give any
Sir, you're
jury
interrupting
instruction.
me and you haven't let me finish. So are you telling me that you are going to disregard my very clear directive to you to not bring up the topic of jury nullification?
That's not what I said.
That's why I'm asking you.
I don't understand that question because that's not what I said.
Sir, you may not argue jury nullification
I'm
to
going
this
to
jury.
inform them of the truth.
So you're going to inform them that they have the power of jury nullification.
They do have the. You just said on the record that they have the power for.
Sir, I direct your
You
attention
just said that.
once
Did you
again.
not just say that, Your Honor?
Sir,
You
the
said I couldn't
jury,
instruct them.
the jury
on
has
that.
the power but not the right to nullify.
Right.
A
You said the
party-
power. You said the
Listen
power.
to me, sir. You're interrupting me once again.
So I'm going to inform them that they have the power.
Are you telling me, sir,
I'm
that
not
you are
telling you no
going
such
to
thing. I
disregard
just told you what you just
my
said.
directive to you to not raise the
He told
issue
you
of jury
yesterday.
nullification during your
He
closing
told you
argument?
That's not what I said. You just read and said that they have the power to. That's what you just said, Your Honor.
Sir, State versus Vjerkas says and stands for the proposition that although the jury has the power of jury nullification,
They have the
no,
power.
no party has the right to argue for jury nullification.
I'm not arguing for it, Your Honor. I
In
just want
that
them to be
case,
informed. I just want them really to be informed.
You
That's
can
it.
call it informing, making them aware.
Yeah, they
Whether
should be aware
you
of
are
the
not
rights.
allowed to make them aware of their power to nullify. That is
can I
an
not make them-
improper argument.
Your Honor, how can I not inform them that they have a power? How
Because
can I
that
not
is not a
inform them
right
of a
that
power
you
that they
have, sir.
have? I'm not giving a new jury instruction.
That is
That's not what
because
I'm
there is
arguing.
no jury instruction for jury nullification,
Yeah,
sir, because it's not allowed.
I'm not attempting to give them a new jury instruction. I'm merely intending to inform them of the power that they have.
Mr.
That's not
Brooks,
against the law.
I'm advising you one more time. You may not raise the issue of jury nullification
I'm going
before
to
this
inform
jury.
them of the power that they have.
He says
I'm not
You are
giving them.
telling me
I'm
that
not
you
giving
are
them a jury
insisting
instruction.
on telling them about jury nullification.
Yeah,
That's
That's-
what I hear you saying.
That's not what I said, though. Don't mischaracterize what I'm saying.
Listen
You just
to-
read and said that they have the power. They have the power to do that. So how is
It's an
informing them?
inherent power that they have. They are not to be instructed on it. That is very clear in the law. In
Your Honor.
addition to, no, let me finish. In addition to the case that I just cited, I'd cite to you from the jury instructions, the law note on jury nullification 705. What that says, sir, is, I'm not gonna read it all, it's many, many pages, but the bottom line is, it is improper for a court to allow a defendant or a defense attorney to make an argument or make the jury aware that they have the power to nullify a verdict.
And Your Honor, you just added this last night. That's why I had to sit there for an hour in the holding cell and wait for you to change the whole paperwork because I brought that up. So you never intended for this to even be an issue.
Mr.
It
Brooks,
never was brought up.
if you
But
think
then
I
when I
wasn't-
raised the issue,
if you
Your Honor, let
think
me
that
finish.
I'm not prepared to deal with an argument on jury
I
nullification,
didn't say
then you
that's not what I said. That's
you are
not what I
missing the
said. In
mark.
all fairness, that's not what I said.
The record should accurately reflect that you were kept in that holding cell
Why was I kept
so
in there?
that my clerk could finish
Adding
the
a jury instruction that was not there.
76 verdict forms, and it's ×2 because there's a guilty and a not guilty
Okay.
for each. No, let me finish.
So
sir.
how
You've
did
interrupted
why did
me
I have
repeatedly.
to sit here for that where I could have just went to my cell and had it delivered? We had this
Mr.
at the end
Brooks.
of last night before you called recess.
I'm not gonna
we
debate
had a
that
whole
topic with
we
you
had a whole
further.
conversation about
Mr. Brooks, you
me
are
bringing up about the jury
defiantly
nullification.
disregarding this court.
Here we
You
go
can
with this.
roll your eyes
Here
at
we-
me
because
all
it's,
you want.
it's ridiculous, Your Honor. You just stated that they have the power to nullify
Would you
any
like,
law,
if you would like,
but then
I
I
will
said
read this to you, sir, the part of the case that's important, but you're not letting me get a word in edgewise. I'm trying my best not to remove you to the other courtroom, but that is oftentimes what I need to do in order for this court to make a full record without you interrupting me. But you need to be fully aware that you may not raise the issue of jury nullification in front of this jury. It is not an allowable argument or an advisement or making them aware. However you want to describe that, sir, whatever verbiage you want to put in front of it, you may not do so. And this court has the power and the authority to limit what you say to this jury, even in a closing argument. And if you're telling me through your conduct, through your words, that you are going to disregard that direction, you will forfeit your right to present a closing argument.
Under what lawful law?
Under State versus Anthony.
It doesn't refer to that.
State versus Anthony may not have dealt with
It hasn't dealt with
the
closing
right
arguments.
to a closing argument, sir, but the reasoning
You just said it right there.
nonetheless is
No.
fully applicable.
No,
because
you
the more
can't
general
change the
principle,
law, Your Honor. You can't change the law. That's
I'm not
practicing law
changing
from
the
the
law,
bench.
sir, but the general
I
principle.
know you used to be in legislation, but you can't practice law from the bench.
Sir, I'm
You
not
can't do
practicing
that.
law from the bench.
You are if you're changing. Your Honor,
I'm not
you're
making-
attempting to make a separate case pertain to something here that doesn't even pertain to it. It has nothing to do with a closing argument. Nothing that you just
So,
named. Not
Mr.
Illinois
Brooks,
versus
I
Allen.
would like to make a record. Would you please show the courtesy and respect for
I
me
will,
to
Your
do
Honor.
that?
I will.
All right. So looking at the Anthony case, all right, and that case starting at head note 7, paragraph 54 says the following, and you need to let me get all the way through it. We have recognized two distinct ways in which a defendant may give up his rights, waiver and forfeiture. State versus Pino is the first citation that they reference. Waiver is the intentional relinquishment or abandonment of a known right. Multiple citations there, I won't.
Object to
Oh
that
God, those spindly fucking fingers,
You
man.
need to make a closing argument, sir, that does not reference jury nullification.
I'm going to inform the jury of their power. Again, I never stated that I was making a new jury instruction. I never stated anything like that. And every case law that you just stated made no reference to closing arguments. It was all pertaining to being present for the proceedings of trial and for testifying.
Sir,
Not
what I'm
one time
telling
did you, hold on, I let, Your Honor, with all due respect, I'll let you make your record.
I don't.
Didn't
You
interrupt.
don't let nobody do nothing, son.
Not one case law that you just cited made any reference whatsoever to a closing argument. Not one. So how is me merely informing the jury of the power and the rights that they have, how is that a forfeiture of being able to give a closing?
this court.
No, this is, I'm supposed to be in this admiralty court because you haven't, if we're under Article 3, then we should be in common law court. That hasn't even been addressed, if we're in a common law court or an admiralty court.
That's a baseless argument, sir.
You're not
And
getting out of
what
this.
law and fact? Based on what law and fact?
It's meritless.
Based on what law and fact?
Sir, I intend to bring this jury out and give you
I'm
an
informed- I'm
opportunity
informed of that.
to present a closing argument.
He's
Yeah,
not
but
If you
you're also-
violate,
you're
please
also-
let me,
but
sir,
listen,
you're
you just
interrupting me
made a
yet
rule.
again.
You just tried to put me under a rule that no one else was put under.
The circumstances require that I implement this rule, sir, given your
The
stubborn
circumstances
defiance
don't,
on
Your
the
Honor.
issue
That's
of
a
jury
prejudice to my
nullification.
defense. You can't place me under certain rules and not place the prosecution under the same rules.
Sir, the
It has to
circumstances
be
of
fair.
this case and your insistence on arguing jury nullification has resulted in
I
this
haven't-
court creating this
I
rule.
haven't argued it. I said that I wanted to inform the jury of their power. I never once said, I'm gonna make an argument, I'm gonna give them a jury instruction.
You may not
I never
advise
said
them
that.
or make them aware in any way that they have the power
And why
of
not?
jury
Why can't they be
nullification.
informed of their
Because
powers?
it would violate the Bajorkas decision, sir.
Violate what decision?
All right, sir, I am going to bring the jury out.
And I'm gonna inform them that they have the power.
And if you do that, I will dismiss the jury and I will declare that your right to present a
can't do
closing
that.
argument
Under what
has
lawful
been
law?
forfeited based upon
Then I make a
how I've
oral, I
outlined
make
that
an oral
to
motion
date.
for
I'm
legal
not going to
finding of
declare that
fact.
at this point because I want to see what you will do. But if you raise the issue of jury
Oh,
nullification, I will immediately dismiss the jury. You will forfeit your right
You can't do
to present a closing
Under what
argument.
lawful law can you?
And then if you continue to
Under
interrupt
what
me,
lawful law?
you will be removed to the other courtroom as I
So I'm
complete
being
the
held in contempt
instructions.
again. Is it civil or criminal?
All right. Go ahead.
I apologize. May I ask the court to consider perhaps an alternative, and I fully respect the ruling the court has just made, and I understand the basis for it. We all know the defendant, in his petulance, will say jury nullification in the first 3 seconds the jury's in the room.
Objection
The-
to that.
Proper
I don't
thing
think
to
that
do,
I should
I
be
think,
talked
Your
down
Honor.
to.
Stop interrupting,
I don't
Attorney
think I
Ocker,
should be
please.
talked down to.
Allow him to make his closing arguments. I will object if he misstates the law. You can instruct the jury to disregard any misstatements of the law. And we continue in that fashion, if possible, for a reasonable amount of time. And if it becomes to the point where there's no reasonable, legal, credible argument that's being made, then the court can decide as to whether or not he's forfeited his right to a closing argument. But we could at least try to, by merely objecting and the court telling the jury to disregard and instructing Mr. Brooks to move on to the next topic, we could try to allow him his opportunity to provide a closing argument. If that's unworkable, then I think this record will be very clear as to the efforts of this court. And I think there is materials in the bench book, or I'm sorry, the jury instruction 705 that talk about a jury instruction. This court could even give, telling the jury that they are not at liberty to disregard the law, but we're not going that far yet because, frankly, you have told them and you will tell them that closing arguments are not evidence. And I think they will abide by that. So I know it's going to require...
Let's give him she's saying let's give him the rope. Give him the rope.
For the court to allow this to...
let him hang himself. Let's just stop the arguing right now. Let's just...
similar to that.
Let's just get it done.
Next step. Or else we will continue at this pace forever.
Oh, wait. I'm going back. Wait, what was that?
Start all at this pace. But I think we should try that or something similar to that in an effort to get through this next step, or else we will continue at this pace forever.
I'm
Certainly willing to try that.
That's about all we can come up with, Your Honor.
I mean, I'm certainly willing to try it in this courtroom if he disregards that, to excuse the jury, and then have him present from the other courtroom would be the second step, and then third would be a forfeiture.
Your Honor, I object to that.
Of course you do.
Your objection is noted for the record. That will be the course of action that this court takes. The first time you violate the rule, you may be subject to forfeiting your right to be present, where you will give the closing argument from the other courtroom. And if you continue in a blatant disregard of the requirement that you not reference in any way jury nullification, I may make that final determination outside the presence of the jury.
I object to that, Your Honor.
All right, with that, let's bring the jury
For
out.
the record, may I respectfully request a legal reconsideration of your ruling?
No.
So is that a tacit agreement that you don't have to answer my objection, Your Honor?
Yep.
I decline to reconsider.
I reject that ruling and take exception to that ruling, Your Honor.
Doesn't really matter.
Noted for the record.
For the record, may I request a legal or factual basis for your ruling, Your
No.
Honor?
Denied.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue, Your Honor?
No.
Denied.
For the record, may I respectfully move for an interlocutory declaratory appeal on this matter?
Nope.
I'm not the court to address that.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction, which this court has no subject matter jurisdiction.
Denied.
Under,
The jury's
based on
coming
what law
in.
or
All
fact?
rise for the jury, please.
Based on what law or fact?
You about to get removed, dude.
Because I'm going to inform the jury of their power. They deserve to know.
Mm-hmm. He's already told you don't listen to him. He don't listen to nobody. You tell me, you axing me.
Thank you, everyone. Please be seated. Go ahead, Mr. Brooks, your closing argument, please.
Good afternoon. It's been a long day.
For your own fucking fault.
First off, I'd just like to start by letting you guys know that it's a lot of information that you guys should be privy to, I believe. And one thing that I believe that you have not been privy to is the truth of your rights and your duties, being the jury. The fact that you and you alone have the power. Not well-prepared DAs with well-prepared and clearly rehearsed speeches and exhibits and a lot of theatrics. Frankly, not the judge. You and you alone have the power. You and you alone decide what is truth and what isn't truth. you should be informed that you have the power to nullify any law that you don't agree with.
Yep.
Objection, move to strike the statement.
Sustained.
Objection.
I will strike from the record the last statement made by the defendant. The jury will disregard it.
Which is clearly what I've been saying. I believe that not only is it fair, but it's essential that you be privy to all knowledge, not knowledge that certain people feel that you should hear and shouldn't hear, disguised under the color of law. The fact of the matter is, just like I did with my opening statements, I don't have a well-prepared or rehearsed speech. I didn't look in the mirror and say certain points to myself over and over again to make sure I have them right. Or
Probably should have.
that. I've chosen to speak from the heart.
Would have been a good idea.
My opening statements, and now I'm going to speak from the heart.
Oh, are you gonna cry again? Go ahead.
What you won't hear me do is argue facts. And the reason you won't hear me argue facts is because I believe that it takes away from what should be recognized. The tragedy of this event. It should be recognized. Trying to
Trust me.
argue facts of this, facts of that, I'm not gonna waste your time doing that.
You already have. Like, that's all you've done.
It's a little emotional. I apologize
Oh
for the long
boy,
pause.
no, please, here we Jesus Christ. Are we doing this again? Is that all you know how to do?
It's hard to keep everything together emotionally. And honestly, I don't believe that
You tell the fucking families that shit.
I have any more tears left. It's been a hard year. For the families, mostly. And that should not be lost on anyone. It shouldn't be taken away. I said it
Well, you
before and I
shouldn't have
said
taken it
again.
away.
It's a lot of people that are healing, that are attempting to heal.
No, there's a lot of people that are not healing. Thanks. To you.
That opens the door to talk about forgiveness for a little bit.
Opens the door. He likes to use these like little lawyer terms that he
Every
picks
healing
up along
process,
the way.
there comes a forgiving process.
What?
It's not an easy thing for anyone.
No. No. You're dumbass.
What you've been hearing from the prosecution, not to take anything away from them, but let's call it what it is. You've been hearing a lot of rerun. Same things over and over and over. No different than when you turn on the radio and you first hear that song that you don't like when you first hear it, but they play it so much that eventually you start saying it, the words to yourself before you even realize it. And then you sit and you go, I hate that song. Why am I singing it? That's what's been happening. Rerun. Over and over and over and over and over and over and over.
No. That's
Attempting to
a
make things
smart
stick in your head
tactic,
that simply
but
aren't true.
no. Nice try.
Why do I say? What am I saying? I say, look at the testimony.
Yeah.
The
All there.
thing from the prosecution here has been intent, 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 intent.
See you later, buddy.
We all know what's been said. We all know the picture that's been painted. Even the prosecution said themselves. How can you look in somebody's head and say, this is what they intended to do? You know, for a year, I've sat and gone through this,
Trying to figure out how to get yourself off. I know.
feeling
I
so
know.
powerless.
I know, because you fucked yourself, and now
Let
there's
other people
no,
run with the
there's no
narratives.
out. Making chopsticks, but they look like
sitting back helpless while other people paint a picture that has zero truth. Zero.
Zero truth. You didn't kill six
I understand
people and
about healing
injured.
myself, tragedy, pain, all that.
Shut the fuck
A
up.
lot of it, there's no need to get into.
Nobody feels sorry for you, man.
I myself in my own life have had to do a lot of healing.
When?
As a man with children myself,
Yeah, I want children who don't live with me. My
I
children who
find it hard to
live
believe.
far, far away from me. That I don't.
that anyone who's really had conversations with me, spent time around me, would think for 1 second that this is an intentional act.
You brought people into the courtroom that said, yeah.
I've never
that
heard
was
of
you. And they know you.
someone intentionally trying to hurt someone
Dude, you're a fucking idiot.
while attempting to blow their horn.
I can't wait for jury deliberations that are going to
Well,
last for 5 minutes.
Attempting to alert people of their presence. Which brings me to more information that I believe that you should have been privy to. And I'm sure that the prosecution will beg to differ. But the fact of the matter is, the vehicle in question, make and model of 2010, Ford Escape. The vehicle in question, actually 2008, 2009, and 2010 of that model was in fact recalled.
Objection, misstatement of the facts, facts not in evidence.
Was in
Improper
fact-
argument, Your Honor.
Sustained.
Was in fact recalled. Was in fact a class action lawsuit against Ford
Objection,
for those
facts not in
models,
evidence,
for
Your
those
Honor.
model vehicles.
Sustained. The jury will disregard.
Information that you should have been privy to, that you weren't allowed to be privy to. Why? I don't know.
Oh, you don't know? Big surprise. Something you don't know.
That information, malfunctioning throttle bodies,
Mr. Brooks, move on.
it's information that you should have been privy to. Vehicles that malfunction and accelerate not being able to be stopped.
Objection, that is
It's
completely
information-
inaccurate,
it's
Your Honor.
information-
Objection, hold on.
Strike.
Go ahead.
Move to strike statements by
Sorry
Mr.
for the
Brooks.
interruption.
They are facts not in evidence, Your Honor, and it's complete misstatement.
Sustained. Strike
How's it a
B.
misstatement when I have the information?
Mr. Brooks, move on.
This is information that
Move
I feel like you needed to know or should have
on.
known.
He's not gonna.
Information that was taken away from you. Why? To prove a case? Information that you definitely should have been privy to.
You done yet? No, you gotta work up some tears. Good job. Maybe they'll
Yeah, he
be
says-
hiring in Hollywood after you finish serving your life.
The defendant has
sentence.
utter disregard for human life. Utter disregard for human life. Not realizing that they're talking about someone that has children.
I have kids.
Talking about someone
I
that
have kids.
watched their
Don't
children
send
come
me
out of the
away.
womb, born into this world, cut the umbilical cord, held them before their mom even did.
Where are they now?
Moments that I'll never forget.
God,
And yet they say
yeah.
disregard, utter disregard for human life.
Oh, anybody's but yours and like your people you know, I guess, maybe. What are you getting at, man? Get the fucking point.
They made reference to a rage,
That's pretty much what
as
it
if they
seemed like, yeah.
were, or if this particular DA was right there, standing right there, as if this DA is a psychiatrist
Oh, we can see you.
I said to myself, "What rage? What do you mean rage?"
How are you showing us rage throughout the entire fucking trial,
How
you
can you
jackass?
characterize that? How can you have the audacity to diagnose what someone's brain is? Where it's at, what it's thinking, why it thinks the way it does. DA makes references to blocks of no one being injured, but then says it's intentional. You add that up with the supposed rage, the supposed intent to harm and kill,
Which you did.
and it doesn't kick in until well within blocks. And maybe it's just me, but I would think if I was characterizing someone with this intent to kill and this rage and this anger, then why weren't people immediately harmed? Why was someone with intent to kill and rage try to alert people of their presence, repeatedly honk their horn? You heard a detective, if you recall, testify that the vehicle that he observed was not only honking his horn, but was not speeding. So where does this rage kick in? Where does this insatiable intent to kill kick in?
You're not helping.
They speak as someone who's known someone for years. Which brings me back to the vehicle. What if the vehicle couldn't stop because of the malfunction?
Objection, fact, not in evidence.
What if the driver of the vehicle was unable to stop the vehicle? Because of that fact, what if the driver may have panicked? Does that make the driver a crazed, or not crazed, a rage? Does that make the driver in a rage and intent on killing people?
Wrap it up, dude. You ain't got much.
DA later, exhibit 17. You don't see anyone struck in that vehicle. On that exhibit, you don't see anyone struck. With someone who had this intent to kill, this rage.
You know, I thought before you were punched
As-
in the
as she
mouth, but
says.
maybe you just got meth now. I think he's got meth now.
If that was their intent, would they have taken the opportunity to hit as many people as they could? Target people, mow down people? Reference was made to this vehicle, the damage. Says this was all caused by bodies, but then later turns around and says hits barricades and other objects. I've heard testimony about hearing loud crashes and things of that nature, but the DA wants you to believe that this all came from people. Evidence doesn't support that. So I go back to trying to wrap my head around everything that's happened in the last year.
It's like some of it was people, but not all of it.
Praying for those families, praying for the people that tragically lost their life. Because
Oh yeah, you're praying. Here comes the Bible.
There was lives lost.
Here comes the Bible
And
with
all the
your
emphasis has
meth
been
mouth
put
and
on
your
the alleged
spindly
defendant.
fucking fingers. I know meth fingers, man.
And the people have been disregarded. Makes me wonder, does the DA even care about those people?
They're not on trial. Fucking pointless.
There's been prayers going up every day.
Yeah, for your own ass. Somebody's about to answer
There's
them
suffering on both
prayers.
sides.
Not the way you want to, Sonny Jim.
There's been threats, hate mail,
Yeah, I bet there.
because of the narratives that's been put out there.
The narratives. You mean, yeah, okay. But
Misconceptions that have been put out there. The lies that have been put out there. Lies that have caused my children not to be able to go to school. To be bullied. For my mother to have to leave her home and stay at a hotel because she's afraid for her safety.
oh, you mean she came
she
to
gets
testify for you and then you wouldn't call
Hate
her?
mail
because you
shoved
didn't
through her
actually go
mailbox.
Dude,
My nieces and nephews to fear for their safety.
you're so full of it, dude. Ain't nobody believe your ass. Just so you know.
And what's
Oh,
been
yeah,
equally
let's-
hard
Try to get them tear works going. You're gonna need that.
It's not only-
Defense.
having to answer the questions from my daughter who was 7 at the time, my baby girl who was 7 at the time.
My
Now
baby
8.
girl. My baby girl. My baby girl. My pobrecita.
Attempting to answer her questions that she's asking and still continue to shield her from what she sees, what she hears.
Heal her. Yeah, I bet you heal her.
Having a newborn son that I haven't even been able to meet. I haven't been able to hold, touch, kiss.
Because you've been a deadbeat dad for how long now, buddy? Tell me. And whose fault is that?
Having to
So
navigate-
it's somebody else's fault, isn't it? Oh, it's all everything.
Everything that comes with this whole situation.
Everything is somebody else's fault. I know. Pobrecito. When we
I'm
all
still
feel so
attempting to wrap my
sorry
head
for
around
you.
it. I can't honestly say how many times I've sat in my cell, especially
my
during
cell.
lights out, alone, where it's just you.
Praying and crying.
And just been praying and asking myself, how could this happen?
You did it.
Not just for the people,
But you did it. You know that part, right?
but for everybody involved, the community too. How could this happen? How?
You did it. That's how it happened.
The hardest questions you can ask is those that don't have an answer.
The one you don't want to answer. Come
No
on.
matter how much thinking you do, no matter how much you try to
Try to justify
look at it from
ripping
different
someone's
perspectives,
head off. Your best
listen to
bet
other
is to
outside
stay away,
perspectives,
motherfucker.
and listen
It's
to
just
people
one of
that you
those
trust and that you
days.
love,
It's all about the he said, she said bullshit.
still coming up with nothing.
Think you better quit talking that shit, punk? You better leave it with a fat lip. It's all about the he said, she
But to think
said
for 1 second,
bullshit.
one question I never had to ask
Yeah.
was if this was intentional. That's something that I never asked once. Because I know it wasn't.
Come on. All right. That's enough of this.
As a matter of fact, Joe, I had to go through this.
You're just talking out your ass, man.
Been shown everything that's been tested. Same thing I said in opening statements, everything you're hearing now. You have the decision. Some days are longer than others, various reasons. Remember the power that you have. Second, let it be taken away from you.
You almost done?
can never understand the position of
There's a lot of things you can't understand, man.
sitting on a jury and something message, but that writing, when we're in our vehicles and we got that rearview mirror and it said things are closer than they appear. But it's also another way of saying sometimes things aren't as they appear.
Really, you just keep talking. Oh man, you're a delay tactic motherfucker. Filibustering is basically what he's doing.
I can't. I believe in your heart. You know what's right.
It's a good word for it, I think. Filibustering.
Thank you.
Thank you, sir. Before I give the state an opportunity,
I want to talk to this guy right
rebuttal.
behind him.
Stand for a minute.
The cop. Because he's had to deal with it this whole time, and I bet it's been fucking ridiculous.
If you want to accuse me of practicing my closing argument,
Uh-oh.
you need fly off the light. It's abandoned. You can. Family,
I skipped. I didn't know they were gonna go for it so quick.
the Duran family, the Hospital family,
Let's see it.
the Kulik family, Sparks family. He wants to talk about how over.
All right, have a seat, please. And Attorney Opper, I did time both closings. You have 13:28 left.
Thank you, Judge. I don't think that'll be an issue. Folks, let me just say this. Mr. Brooks stands here and professes to speak to you from his heart. He plays on your sympathy. He talks about his children. He talks about the
Uh-oh. He opened the
hardships
door.
that he's encountered and his family's encountered. And he brushes over the loss to the community. He wants to talk about how he's never held his newborn son. Never once acknowledges the Sorensen family, the Owen family, the Duran family, the Hospital family, the Kulik family, Sparks family. Never once. It's nice that Mr. Brooks can get letters from his loved ones. I don't know why he did this. I told you that. But actions define a person. It's that simple. You can stand with the Bible in your hands all day long and profess to be the finest man under God that you can be. But when you drive through a parade route and roll over children with band instruments to the extent that your vehicle heaves up and down, your intent is known, Mr. Brooks. It doesn't have to be guessed. It's known. You don't have to stand and wonder as he claims to. For him to keep going after he drove over those children in the band and have Jackson Sparks fly off the front hood of his car, lifeless, and keep going. And have Jane Kulik fly off the hood of his car, run her over, and keep going. I'm not going to go on. You get it. You need to look in the mirror, Mr. Brooks. If you want to accuse me of practicing my closing argument, you need to look in the mirror, sir. Your actions are that of a murderer. You murdered these 6 people. You endangered the safety of 61 others. There are 68 victims in this case, folks. That's not an accident. That's not a, gee, I woke up one day and don't know how I found myself in this position. If you have some explaining to do to your children, Mr. Brooks, I recommend you do it.
Objection.
Objection.
Now, members of the jury, the duties of the parties and the court have been performed. The case has been argued by the parties.
Yes!
The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has
Sing
now
it,
come from the
sister!
great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or
He's gonna
passion.
get removed.
You'll be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict.
I'm just guessing. I'm
You are to
guessing he's
decide
gonna get
only
removed
whether
again.
the defendant is guilty or
During
not
this.
guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 76 forms of verdict will be submitted to you concerning the charges against the defendant, Darrell E. Brooks. Count 1. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 2.
He
One
did.
reading, we the jury find the defendant, Darrell E. Brooks, not
Spoiler
guilty of
alert!
first-degree intentional homicide as charged in count 2 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 3. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 3 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 3 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 4. Excuse me. Count 4. Count 4. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of
She's got like
first-degree
30
intentional
pages
homicide
of
as charged in count 4 of the information. Another reading, commit first-degree recklessly endangering the defendant guilty of first-degree recklessly endangering safety. The first-degree recklessly endangering safety. Endangering safety while using a dangerous weapon. Count. So, endangering safety. Answer the following question: yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? We're going to have you take a short stand break while I confer with Madam Clerk.
You see that look?
I'm sure you
Them eyeballs. You got them greasy eyeballs, son. Get this guy in the military.
Another reading, we the jury find the defendant. Another reading, we the jury find the defendant, Darrell. Another reading, we the jury find the defendant, Darrell. Safety is charged in count 58 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 58 of the information. Another reading, Darrell E. Brooks, guilty. All right, would you all please raise your right hand? Do you swear that you will keep all
There we
jurors
go.
on this trial deliberation room and will only be called upon if needed, of course, after consultation with the parties? As far as how late I will let them deliberate tonight, we have ordered dinner for them. I believe it will be here shortly. And I really will leave it up to them as to how late they want to deliberate before they would want a break and then to retire for the evening. They are under a sequestration order, so they will be kept separate and apart. Their electronics have been confiscated, and they will not be going home until verdicts have been reached or they are discharged from the court, whichever would occur sooner. Anything else the parties would want me to address at this moment on the state?
Thank you, Judge.
Anything from you, sir?
Yep.
Yep. You know there would be.
So essentially, I'm gonna have to stay here while they're delivering. I'm gonna be able to go back to my unit, use the phone, shower.
No. What?
It is shower day for my pod. We only get 2 shower days a
I don't,
week.
so here's what could happen though, sir. I don't have a problem with you doing that, but they could have questions. And then you would need to become available so we could address any questions. They may ask for exhibits, things of that nature. So as long as you're willing to come back for those things, I don't have an issue if, I probably should talk to the COs or at least the sheriff and make sure I'm not stepping on their toes since they're in charge of all of that. but it's possible that we get a request for exhibits, some exhibits initially. I wouldn't be surprised if we got that. So let me do this. Let me confer with the Sheriff's Department. I don't initially see an issue with that, but I want to make sure that they have a protocol in place and that's what they would like to do as well, okay?
And one more thing.
Go ahead.
I was curious. 61 charges for reckless. 61 injured parties did not testify. So how does that work? How
I'm not here to explain.
essentially how are charges able to be charged if all of the injured parties did not testify?
From my perspective, sir, the state presented their theory of the case, and there was sufficient evidence regarding the charges to go forward to the jury. I can't further explain it from there because that would require me to explain the law. And
I'm not
I
here
guess
to
that's all I
explain
can
the
really
law.
say about it at this point.
I got a point though.
I'm sorry?
I got a point though.
No, you don't.
Um,
Maybe on the
I'm
top
not
of your
gonna
head,
comment
or
on that,
on the
sir.
back of your little elf ears.
Of course, the state bears the burden of proof, and they
Oh,
have to
he-
convince a jury beyond a reasonable doubt.
He's been trying to play gotcha the entire time.
For better or for worse, sir, I
Suck
was not
that.
presented with any motions to dismiss, either at the end of the state's case or the close of the evidence, regarding any legal arguments you may have had regarding those issues. And so at this point, the jury has
You're
the
done.
case, and they
You're done.
will determine their verdicts. If there are issues of law that you want to raise after the verdicts are received,
All right, suggest you go to law school.
then you'll have to make that determination.
Yeah, that has to be raised because it's essentially you can't. If no injured party testifies, then it shouldn't be a charge.
Wrong.
I disagree with that characterization, sir, but there is frankly no motion in front of me based in law or fact, so for me to comment any further would require me to give an advisory opinion, which I'm not willing to do.
So you saying I need to make a motion?
So what I will say at this point is I do have
have
one
time to
issue
make-
that I would like to raise with the parties. I frankly I need a break a little bit. I mean, obviously the court has to stay open. I know my dinner is coming. And I think it's reasonable. I need to put a few things together, but I do need to make a record of some information that I received earlier today, so that the parties are advised of that. But I will do that. Let me confer with the Sheriff's Department about your requests. I'd like to take in about 30 minutes, address the issues that I need to address, or the issue. And I want to find out if that would interfere.
Hello.
Hey, sorry, are you at practice or something?
I'm at the office right now. What's up?
I already called animal control about it. They said they can't do anything about it, but there's a hog.
Well, I apologize about that. My wife just called to let me know that
Here with your
a wild boar running around in our neighborhood, and I told her that if it's still running around in our neighborhood when I get in that neighborhood, I'm probably gonna go and fucking kill it. Of course, she loved that answer because she loves, manly men.
request about taking a shower and all of that. So if you can hold tight and stay with us for a little bit, that would be great. And I'll confer with the sheriff's department and have a more definitive answer for you shortly, okay?
Can I get my filings?
You want the originals back. If Madam Clerk has scanned them all in and they're uploaded, I don't have an issue giving you the originals back. They will have the date stamp. They don't have a time because they were filed in court.
He's hoping for
Also, so that they were in there, printed them after. I
either a
scanned them, so
retrial or
So you're getting 2 copies.
an appeal. So
Okay.
that's what.
See, I didn't interrupt you. See,
That's
I'm sorry?
the reason-
I said, see, I didn't interrupt you.
Oh
Thank
wow!
you, I appreciate that.
Oh wow!
Unless I would like the parties back in about a half
Did
an
the
hour.
bare fucking
Thank
minimum.
you, unless they have a question sooner.
Yeah. Fuck you.
Your Honor, do I have to go in that holding cell or do I get to go?
Are we done? Done with that one.
I don't consent to being called that name for the record.
I think it's the same shit.
Paperwork I accept for value in
They
return.
still? What's going on here?
In this courtroom, unless you can promise me right now, you'll respect
That earlier.
count 73 of the information. Still have that, okay?
See, I didn't interrupt you. See,
I think we finished for today. I think we finished. I think we got all the way through it. Oh my god! Oh my god! Juries and deliberations. Ah, yes, yes, and yeah, it was not quite as exciting as I would hope it would be. Yes, he was ridiculous as I expected him to be, but I don't know. It was, I don't know. It was just, there was some lackluster to it. Oh well. Well, I hope you guys enjoyed hanging out. I apologize. I'm gonna go see if I can find myself a big ass pig and go kill it. Take home some dinner and some skins and some fat. Yeah! Yeah! Let's get it! Yeah!